Case number 115278, State of Kansas v. David Mears.
Thank you, Your Honor. Lance Gillette on behalf of the State of Kansas. If I could reserve 3 minutes for rebuttal, please.
3 minutes is granted.
For the benefit of the audience, a brief factual recitation. In the instant case, David Sheldon Mears was charged with felony driving under the influence and a number of traffic infractions subsequent to a traffic stop. He submitted to a breath test in this case, indicated that his blood alcohol content was 0.231. The defendant did raise a challenge below to whether or not one of his prior convictions, specifically the one from Wichita Municipal Court, could be used to enhance his sentence. He did not challenge a prior DUI from the city of Bel Air. This issue was litigated at the district court level. And here, while admittedly I don't recall that the district court had the benefit of Mathis when it conducted its analysis here, the district court actually did exactly what Mathis suggests and tells this court we are to do, and it took a peek at the record documents in the instant case, and it found that the defendant's argument might have had merit if the charging document had generically alleged that the defendant was operating a vehicle under the influence of alcohol. But that's not what the charging documents alleged in this case. The district court found that the type of vehicle was an element, and the defendant's prior would count to elevate the current case to a felony.
And the charging document said, I think Judge Gary said a Ford pickup was it defined?
Correct.
More than that, or just
as far as elementally, no. For other language other factual language in the surplusage of the charging document, referred to it as a blue Ford pickup.
So, did the city prosecutor have to prove that it was a Ford pickup?
I believe they had to prove that it was a pickup.
Why not the Ford? Once it was charged.
Because I don't believe that the make matters. That would be one of those surpluses.
How do we decide?
Huh?
How do we decide? Even when it's in a charge, especially given our law on charging now, and what charging documents have to include. How does Peking tell us whether it's being charged as an element or just included as a fact? Let's say we get there, which I think is about step 7.
Right.
But let's say we get to step 7 and we're peaking.
Mm-hmm.
How can we tell? In a single case, how do we tell whether that's being charged as an element or just included as a fact?
And I think it's a difficult question in a single case, but this court's used to answering difficult questions. And I think that when you can look at the record from a single case and you can see that it was charged not blandly as vehicle in general, but specifically as a pickup, then you can determine that the city of Wichita treats the type of vehicle as an element. If
Is
it
it
just
the
said
to-wit?
Huh?
Is it the to-wit? A lot of charging documents say, deadly weapon to-wit,
Right.
and then they give you a fact.
I don't think the charging document does include the to-wit here.
No, I don't think so either.
Yeah.
So that's not a clue here, but
Well, I
that
think
would
it's a
help us
clue.
in some, right?
I think it's a clue that it's an element as opposed
Okay.
to merely a fact.
See, that's where I'm unclear is where you draw the line, whether the state has to prove just that it was a vehicle, whether it has to prove it's a motorized vehicle, whether it has to prove that it's a pickup rather than a sedan or a convertible, and whether it has to prove the make of the pickup, or even the body style. I mean, along that progression, where do you move from an element to a alternative fact to prove that element?
Option within a mean.
Right.
Or option within a mean.
Right. And I think that you have to treat that as, you have to look at the definition. Wichita Municipal Ordinance defined vehicle as every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except devices used exclusively upon stationary rails or tracks. So essentially you have every device. So we have to look at the device. What was the device? You need to go no further than device.
Why do we need to specify which device if the element is just a device for carrying people?
Because the element is the element. I guess the element would be vehicle. The type of device could be an element or a fact, but here it is a element, and that in part comes back. That circles us back. And
And
to
so,
Hackett.
to answer my question, where is it that we get to the element? We have any device to carry people on the highway,
Right.
okay? That would include vehicles, correct? I mean, that is the definition of vehicle. At what point then do we get to the element? Is it when it's motorized? When it's an automobile, four-wheel automobile?
Right.
Is it when it's a pickup truck, or is it when it's a Ford pickup truck, or when it's a Ford F-150 4x4
Versus 250.
Yeah,
Sure.
yeah.
And I think that this court would be wise to go back and look at Hackett. I think Hackett tells us. Hackett is a post apprendi case where this court looked at a prior conviction and they answer the question whether or not a DUI that arose under the Wichita Municipal Code could be a prior conviction in a subsequent state proceeding. In the case of Hackett, where his arose on a bicycle, they said no. This court said no, but said nothing about the fact that other devices, types of vehicles, those meeting the state definition of vehicle, those would still count.
It was post apprendi but pre-DeCamp, right?
Yes.
There's quite a bit about apprendi that nobody understood at the beginning, isn't there?
I mean,
Aline, for example,
yeah, Apprendi clearly has been honed over time. There's no doubt about that.
expanded. I mean, it seems the one area in criminal procedure where the court is
Was it
hot to
Aline?
trot on defendants' rights.
Aline definitely expanded it. The other cases, I think, have mostly honed it. That we're talking about, increasing maximum sentences versus increasing lower sentences, and
Right.
everything else is just honing what are we able to look at without violating constitutional rights. To that end, even again, Hackett is a post-apprendi case, but I want to address the absurd results scenario that's been talked about a few times here, and frankly, the absurd results. Well, number one, it wasn't argued below. Number two, you don't get there here, because when you look at this municipal ordinance, the Wichita ordinance, it does prohibit the acts. It doesn't go so broad as to become absurd. So if that's an avenue that this court wants to go down, then so be it, because this comes all the way back to the original arguments I was making in Gensler. I think that there's a reasonableness that comes into play
Well,
here.
but that's not consistent, as my colleague at the end of the bench pointed out, with your plain language argument. I mean, if you want to say plain language, then we have to look at all the plain language, don't we? Including the definition.
Yes.
And that definition, I think we already have reviewed, might lead to some pretty absurd results.
I don't think it would here. I just don't see that it would here, because the plain language of the statutes in play here.
Any
Granted,
behavior while drunk could be covered.
it's possible, but that's not here. And I think that what we have
But
here
we don't know that
is-
without knowing
is
more than we
analogous.
might be permitted to look at. That's the problem, is we get stuck in that vortex.
Well, and I don't think, and I want to be clear again. There's no reason to become stuck. Mathis is the tool. Mathis is the tool that allows us to get through this analysis.
We don't need Mathis. We don't need any federal constitutional law at all to look at the municipal ordinance and understand it, presuming it's not ambiguous, right?
Correct.
Let me, on a related topic, but a new question.
Sure.
What do you think of the line in Hackett where we previously discussed the these statutes and said, the statutes disclose that the legislature intended to limit the consequences of a DUI conviction to those acts prescribed by state law. What do you think of that? That undercuts your plain language argument, or at least it arguably does.
It does.
What do you think of that?
And I addressed that a little bit in my brief. And even if at the time of Hackett that were true, I think that that the DUI law has changed sufficiently enough since then that even our own state DUI law allows for prior convictions for boating under the influence. It allowed for refusing breath tests. These are items that are absolutely not a common DUI, but state statute directs that they be scored as a prior DUI. So I think that, while my primary argument is that we should just follow Hackett, follow Mathis, the tools that we have. The alternative is if you go to plain language, I think you do have to revisit Hackett, and that it may have reached the wrong result because
On legislative intent,
or that its result is no longer valid on legislative intent. Correct.
not on the home rule issue, but on the issue that it sort of dived into about legislative intent.
Yes, absolutely.
Was that dicta?
Which part?
Was the part that you're talking about in Hackett, was it dicta?
Which part? I'm sorry. The question that he had asked about.
Yeah. Mm-hmm. I mean, it was a home rule case, right? Overall.
I mean, that was the primary focus, yeah. But
Yeah.
there was absolutely a secondary question of whether or not a prior DUI under Wichita Municipal Code would be able to be counted as a prior in a subsequent state proceeding. Again, I would just reiterate, I think over the three cases that we've covered this morning, I've addressed basically every issue that I can think of. Again, I would suggest that we, as a primary rule, we should follow Hackett, follow Mathis. Hackett absolutely recognized divisibility within the Wichita Municipal Ordinance. There's no reason to change that. All of the arguments that I've made previously indicate that divisibility still exists. One thing I guess I did want to touch on very briefly, if I've got a minute left before rebuttal here, though, is one thing that does differentiate these cases from some of the discamps and the cases like that before is the definition that we have. And that's part of why I guess it kind of hooks back to the plain language. In the prior cases, discamps and that line of cases, they're under the Armed Career Criminal Act, federal law. There's absolutely no definition for burglary. Here, we have the definition. The statutes give us the definition. And in this case, that definition of a prior is a conviction under an ordinance which prohibits the acts that this section prohibits. And defendant's prior absolutely arose under an ordinance which prohibits the acts that KSA 81567 prohibits. His prior conviction was properly counted. The district court, be it through luck, wisdom, excellent judicial work, predates, I believe in this case, predates the Mathis analysis and conducted that analysis appropriately here. If I see no further questions, I will yield until rebuttal.
Thank you, Counselor.
Thank you.
May it please the court, Ryan Gehring for Mr. Mears. I would like to start off by getting into, I think we need to talk about the Hackett issue a little more. I know I discussed this briefly earlier, but the way that I read the Hackett opinion, the City of Wichita versus Hackett opinion is they get into the situation and identify that the municipal ordinance is broader and come out and flat out say that DUIs on a bicycle would not count. But the overall question in that case to me is, what do convictions under this ordinance, what happens with those now? It's not, because there's no separation between the two. When you look at a conviction for DUI in the City of Wichita, it's a violation for ordinance 11.38.150. No matter what it is, at the end of the day, that's what it is. And when you look at that, you can't tell factually what happened. And I think that's what this court in Hackett was saying is, since we're saying that some of these don't count, and we can't tell by looking that none of them can count. I think that that's what Hackett stands for, because it all comes back to what's the element? The element's vehicle. Any one of those things can count. And I really think that's what Hackett stands for. I also wanted to address, in regard to, well, I guess both the state and the city changing their ordinances. And I know that council was asking questions earlier about what do we think that means, that the city changed their ordinance. And I think that it's pretty apparent that what it means is, oh no, we got warned in Hackett, we didn't listen, and we better fix it now because we see that this problem is here now. I don't think it's an indication that, hey, we were doing this all along, but we're just going to change it just because. I mean, I think it's clear that they realize that there's an issue with that. And in regard to the state adding refusal laws and DUIs in boats and whatever, they've listed all those things very specifically in the statute, that those things are to be considered prior convictions. And the city of Wichita Hackett case was 14 or 15 years ago. I mean, if the legislature intended to include this stuff, they very easily could have done that, and they haven't. If they had, obviously we wouldn't be standing here, but that's not been done. And I think that speaks volumes as well. I know that you all have heard the argument several times today already, but our position, Your Honors, is that the municipal ordinance doesn't prohibit the acts that are prohibited by KSA 8-15-7, 1567, and that there's no mechanism where we can get to a situation where a judge can find that fact of what vehicle, I guess, what device, I guess, was used during the commission of the prior offense. In any of those findings, I think, run afoul of both Apprendi and Alene, and under the Dickey and Mathis and Deskamp's analysis, I think we end up back at the categorical approach, which is we look at the elements of that offense, and the elements don't match. They don't prohibit the same acts, and therefore we don't end up with the prior conviction. And lastly, again, even if there was some mechanism where the judge could get to where they could make these findings of fact, we still end up in a situation where we've got a judge making a finding of fact, and it's that finding of fact that's increasing the penalties in the current case, which I don't think we can have. So we would ask that this court find the same way that the Court of Appeals did, and that Mr. Mears' Wichita Municipal Court conviction does not count as a prior conviction, and have the case remanded for sentencing. Unless there's any questions, I don't have anything further.
Counsel, this would be your last opportunity to present to us. Anything, you have nothing further then?
No, Your Honor.
All right, thank you, counsel.
Thank you.
Just very, very briefly, Your Honors, I don't think that Hackett stands for the proposition that no DUI under the City of Wichita Municipal Ordinance can count. If this court had intended Hackett to stand for that proposition, it would have expressly said so, and could have said so in that case. It absolutely could have. Secondly, as far as
But that was the heading of that particular section. The question presented was a conviction for DUI under the Wichita Ordinance of prior conviction. It didn't say it was a conviction for human-powered.
Right.
It didn't explicitly say that it was answering that question totally yes, but it didn't limit it either.
And I understand what you're talking about. There was a concurring opinion in the instant case where they dealt with that potentially confusing heading, and there are different ways to look at that. I grant you that. I think the clearest is to treat it as dicta, because the actual analysis, the actual holding in Hackett was that only bicycle, human-powered DUIs are excluded for future state purposes. I guess one other point to touch on as far as the statute, the Kansas statute, potentially the reasoning of Hackett, if for some reason it were no longer viable based on legislative intent, it is possible for the legislature to list certain statutes, such as boating under the influence, refusing breath test, etc. It is a whole other ballgame to address different municipal ordinances from the over 100 different counties in the state of Kansas. Could they easily include them? I think they tried. I think that's what the statute here is to try to say if that municipal ordinance prohibits the act, I'm going to make sure I use the precise language. If the prior conviction arose under an ordinance which prohibits the acts that this section prohibits, then it counts. There is room for cities and counties to go a little bit further if they want, but so long as their ordinance at least covers the acts that this section prohibits, I think it is a reasonable effort that the legislature made here, rather than trying to list out what could potentially be thousands of different options that would become unwieldy and unworkable.
Does the fact that it says the acts in the statute versus an act in the statute make a difference? I mean, does that wording make it that they almost have to be parallel?
I think the fact that they use the acts is beneficial for the state's position, in that they want to make sure that the municipalities at least follow the state law. They have to prohibit all of the same that the state prohibits, the same acts that the state prohibits. If they choose to prohibit some more, that's okay. They can't just say, well, we only prohibit driving under the influence if you're at 0.08, and then expect whatever else the municipality might try to cram into such an ordinance to count. It has to, at the very least, prohibit the acts that the state prohibits, and it does here. Again, just if I may, Your Honor, 30 seconds to wrap up. My primary position is that there is no reason to depart from Hackett. If we follow Hackett and we follow and utilize the tools that the United States Supreme Court has given us in Mathis, this case can easily be resolved in the state's favor. And our second position, again, would be to come back and consider the plain language of the statute, reconsider the legislative intent. I don't even think we have to get there. Again, all we've asked from the get-go is that the defendant's constitutional rights be protected, but that he be subjected to the appropriate penalties under the law. If there are no further questions, I thank this court for its time this morning. I rest.
Any further questions? Thank you, counsel.
Thank you.
We thank both of you for your patience this morning on these three cases. Clerk will take this matter under advisement.